The state versus JANSEN van RENSBURG and 5 others. Case number A604 of 2026. This is regards to Emmanuel Mbense matter. Brakpan Magistrate Court at Ekurhuleni, Southeast. The accused are, accused number 1 is Cobus JANSEN van RENSBURG, who owns Coast Guard Security. Accused number 2 is Wayne Sibande, a former SAPS sergeant. Accused number 3 is Adrian Norman Mackenzie of EMPD. Accused number 4 is Keisha Lee Stokes of EMPD. Now, accused number 5 is none other than Julius Dr. Mkhwananzi, chief of EMPD. Accused number 6 is Jean Marie Exton of the SAPS. The draft charges are all under Schedule 6. Count 1 is the unaliving. Count 2 is robbery with aggravating circumstances. Count 3, defeating and or obstructing the cause of justice. For bail, the accused bear the burden of showing exceptional circumstances which, in the interest of justice, permits their release. Accused number 1, Cobus JANSEN van RENSBURG, the owner of Coast Guard Security, the alleged organizer. Cobus allegedly contacted witness D repeatedly and told him he had an operation planned against a warehouse robbery suspect. He sent witness D the meeting location. Witness D says Cobus and Yako Hanekom briefed the assembled team before they proceeded to Mbense's house. After Mbense was apparently dead, witness D alleges that Cobus was among those looking for a firearm to plant at the property. The following morning, Cobus allegedly repeatedly called witness D, asking him, "Where did you put the body? What are the chances someone will find it?" Witness D says Cobus then went with him to the disposal location so that he could show him. Now that he is accused, in his bail application, he says that the state cannot properly connect him to the crimes. He relies on the alleged weakness of the state's case, cooperation with investigators, strong family, property, business ties, willingness to surrender his passport, and the prejudice continued detention would cause him, his family, and employees. Accused number 2, Wayne Sibande, the common purpose question. So the common purpose thing still comes up. Witness D does not specifically attribute Sibande to an assault, theft, disposal of the body, firearm, all that stuff. Sibande faces the same 3 charges. The state says he was present at the operation. He had knowledge of what happened, so that's why they tie him up with common purpose. Accused number 2, bail application, he says, "No, yes, I was there, but I was not part of the crime." Sibande says he responded to a request for backup, was assigned to search the yard and outside the rooms. He never entered the main house, never saw Emmanuel Mbense, witnessed no assault, robbery, or murder. He left before the alleged body disposal. Has another officer corroborating his early departure. He is excluded by forensic testing from relevant DNA exhibits, attended no subsequent meeting, and never joined any prior agreement or common purpose. His essential defense is present does not mean participation. Accused number 3, Adrian Norman Mackenzie. This name keeps repeating in every single crime. The alleged route to the dam. From witness D's testimony, Mackenzie was present when the operation was assembled. Witness D says He, Exton, which is accused number 6, and Norman Mackenzie entered and searched an outside room occupied by a man, woman, and a baby. After information came through that Mbense had been located, witness D says they proceeded towards the main house. He specifically places Mackenzie with him, and when he entered through the kitchen. But witness D does not say he saw Mackenzie torture Mbense. That is important. The far more serious allegation comes after Mbense's unaliving. According to witness D, the body loaded into his vehicle, Mackenzie leads and directs him to the water pen, and Mackenzie allegedly tells him to dump the body. Witness D physically dumps the body of Emmanuel Mbense. So accused number 3 participated directly in the disposal phase. Other statements in the state-owned 2022 docket support his limited role and do not identify him as an assailant, only as somebody who disposed the body. So in his defense, accused number 3 says, look at the state-owned old docket. It does not tie me to this. Mackenzie says he was principally in the yard, had limited involvement, and was eventually told his assistance was no longer required. He relies on older witness statements and forensic evidence, which he says supports his account and excludes him from the relevant DNA material. Accused number 4, Keisha Lee Stolz, who was inside the house searching kitchen cupboards. Stolz was part of the assembled EMPD contingent, according to witness D. He places her inside the main house. He specifically says he saw her searching kitchen cupboards. Later, he says Pretorius and Stolz emerged after the fatal assault, with Pretorius allegedly saying he would never, ever talk again. Witness D also says Stolz attempted to contact a paramedic to have Mbense declared dead, but there is an important evidential limit. Witness D does not say he saw Stolz unalive Mbense. He expressively says he cannot say how Mbense died because he was not present when the fatal event occurred. And although searching cupboards may become circumstantial evidence relevant to the robbery allegation, searching a cupboard in itself does not prove theft. So in his bail application, he says, I was called as a backup. Stolz says Honeycomb requested agent assistance in connection with armed suspects and told her commander had already been informed. He says he arrived to find numerous personnel already at the premises, questioned why her assistance was even required, and subsequently withdrew. Her essential argument is that responding to an operation does not mean joining an unaliving, robbery, or cover-up. Accused number 5 is none other than Julius Dr. Mkhwananzi. He enters this story after Mbense has been unalived. This is the most important distinction in accused number 5. Witness D does not place Mkhwananzi at the initial raid or torture or search, whatever they were doing. But witness D says Mkhwananzi arrived after Mbense was already non-responsive. It was, according to witness D, the first time he had ever seen Julius Dr. Mkhwananzi. So Mkhwananzi arrives, Mkhwananzi, Honeycomb, and other alleged hold a private discussion away from witness D. They return. Mkhwananzi says the body needs to be thrown in a mine shaft and dumped in a dam. Witness D says Mkhwananzi looked straight directly at him and told him that he must take the body. And witness D interprets Mkhwananzi's look and the preceding private discussion as meaning that the group had selected him to dispose of the body. Important limit. At the later Rose meeting, Honeycomb says the chief will cover them. Witness D associated the chief to mean Julius Dr. Mkhwananzi, but when challenged at the commission, he concealed that nobody actually said Chief Mkhwananzi or Julius Mkhwananzi, but the word chief was said. That identification was Witness D's own conclusion. That must be kept separate from Witness D's alleged that Mkhwananzi himself proposed a mineshaft dam. In accused number 5 bail, he says, I wasn't part of this raid, and Witness D's allegation is unreliable and they need to be thrown out. Mkhwananzi denies ordering or participating in the disposal. He attacks Witness D's reliability and says Witness D was given contradictory accounts concerning his involvement. He also relies on the fact that he knew the arrests were coming, nonetheless presented himself to the police. Accused number 6, Jean Marie Exton, the alleged cover-up role. Witness D gives considerably more detail against accused number 6 than simply placing her at the scene. Witness D says Exton was present when the operation assembled. She allegedly entered an outside room with Witness D and Mackenzie and identified herself and questioned the occupants about Mbense. They subsequently proceeded towards the main house. Witness D does not say he saw Exton assault Mbense, but after Mbense was unalived, Witness D alleges that Jean Marie, Fritz, Coppers, and others were looking for a firearm to plant in their house. After Witness D disposed the body, he says Jean Marie telephoned asking whether it had been done. At Carnival City, she allegedly said, how deep did you put the body? And when Witness D explained where it was, Exton allegedly insisted that he return to check whether the body was still there or had it been seen, and Witness D refused. Accused number 6 bail case concentrates heavily on flight risk and cooperation. She points to her family and property ties, 3 minor children, and the fact that he had been working temporarily in Dubai. Her argument is effectively that she had genuine opportunity to remain outside South Africa, but nonetheless returned and cooperated rather than absconding. On the merits, she disputes that her presence at the operation established participation or in a common purpose to murder, rob, or conceal the Mbense death. This is the beginning of this bail trial. Please help me from my page and my channel by sharing your thoughts in the comment section, including any corrections in my narration. Did I miss anything? Also, share my content in your network. Follow me as I will give you updates on every single accused person in this Emmanuel Mbense matter. The bail checklist is that so far the defense and primary evidence has been completed from accused number 1 to accused number 6. They've put up their bail cases. The state opposition before the court is done. What is left is the defense reply or supplementation, potentially outstanding. The oral arguments have not been heard. The bail judgment has not been given. So please remember to follow me as I will be giving you updates on all of these outstanding items that are here The next court appearance is Tuesday, 18 August 2026 in Brakpan Magistrate Court, and all of the accused remain in custody. I think they would be reaching their third week in custody. See you on the next one.